Please be seated. The sitting is open. Before we start our judicial proceeding today, I would first like to pay solemn tribute to the memory of Judge ad hoc Srinivasa Rao, who sadly passed away on 17 March 2025. Judge Srinivasa Rao sat as a judge ad hoc in the case concerning sovereignty over Petra Blanca, Pulau Batu Pete, Middle Rocks, and South Sledge, Malaysia, Singapore. During his long and illustrious career, Judge Srinivasa Rao served the Indian government at the highest level, heading the Legal and Treaties Division of the Ministry of External Affairs and acting as Chief Legal Advisor on International Law from 1985 to 2002, as well as represent his country at various international legal conferences. He was a member of the International Law Commission from 1987 to 2006 and was elected as its chairman in 1995. He also acted as arbitrator in the Bay of Bengal maritime boundary arbitration between India and Bangladesh between 2010 and 2014. That same decade, he served as first vice president and president of the Institut du Droit International. He was also invited to lecture on law as visiting professor at various prestigious universities. These are just some of his many professional achievements in a life dedicated to upholding the value of international law as a practitioner, an advocate, a judge, and an academic. As a judge ad hoc at this court, Judge Srinivasa Rao is remembered with much fondness by his former colleagues who admired his ability to combine sharp, independent thought with a marked sense of collegiality. Judge Srinivasa Rao was a leading international jurist and a man of great integrity. He will be missed. On behalf of the members of the court and myself, may I offer our sincere condolences to the family of Judge ad hoc Srinivasa Rao. I invite you now to stand and observe a minute of silence in his memory. Thank you very much. Please be seated. I shall now turn to the judicial proceeding before the court today. The court meets this morning under Article 74, Paragraph 3 of the Rules of Court to hear the single round of oral arguments of the Republic of the Sudan on its request for the indication of provisional measures submitted in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan, Sudan versus United Arab Emirates. The court included upon the bench no judge of the nationality of either party. Accordingly, both parties availed themselves of the right under Article 31, Paragraph 3 of the statute to choose a judge ad hoc to sit in the case. Sudan chose Mr. Bruno Sima and the United Arab Emirates, Mr. Philippe Kivrugo. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, the same provision applies to judge ad hoc, who have to make a solemn declaration in each case where they participate, as stated in Article 8, Paragraph 3 of the Rules of Court. In accordance with the court's practice, I shall first say a few words about the career and qualifications of Judge Sima and Judge Kivrugo, before inviting each of them to make their solemn declarations. Judge Bruno Sima, of German nationality, served as a member of the court from 2003 to 2012 and was appointed as judge ad hoc in the joint cases concerning maritime delimitation in the Caribbean Sea and the Pacific Ocean, Costa Rica versus Nicaragua, and land boundary in the northern part of Isla Potias, Costa Rica versus Nicaragua, and in the case concerning the dispute over the status and use of the waters of Silala, Chile versus Bolivia. Judge Sima studied law at the University of Innsbruck, where he obtained a doctorate degree in 1966. In 1973, he became professor of international law and European community law at the University of Munich, where he went on to serve as dean of the faculty of law between 1995 and 1997. Judge Sima also has a long-standing academic career at the University of Michigan Law School, where he began teaching in 1986, was appointed professor of law in 1987, and where a chair was created in his name in 2009. He has twice been the Director of Studies of the Hague Academy of International Law, and in 2009, he delivered the prestigious General Course in Public International Law. His publications in international law are numerous and well-known. Judge Sima was a member of the International Law Commission from 1996 to 2003. He has appeared as advocate in various cases before the court and has sat as arbitrator in numerous arbitral tribunals. Since 1st December 2012, he has been an arbitrator at the Iran-United States Claims Tribunal. Judge Sima is the recipient of numerous awards, including honorary doctorate degrees. Judge Kivrugo, of Belgian nationality, served as the registrar of the court from 2000 to 2019, having previously held various positions in the court registry since 1982, including that of principal legal secretary. Judge Kivrugo studied law and philosophy at the University of Namur and the Catholic University of Louvain, before completing his postgraduate studies in international and European law at King's College London and Complutense University of Madrid. In parallel with his illustrious career at the court, Judge Cabral has taught law as a visiting professor and guest lecturer at various universities. Judge Cabral has also given courses at both the Hague Academy of International Law and the Sherman Academy of International Law. Since stepping down from his function as registrar, Mr. Cabral was appointed as judge ad hoc in the case concerning Guatemala's territorial, insular, and maritime claim, Guatemala-Belize, and in the case concerning the arbiter award of 3 October 1899, Guyana versus Venezuela, both currently pending before the court. He is also a judge ad hoc at the International Tribunal for the Law of the Sea and serves as an arbitrator in investor-state proceedings. Judge Cabral is an associate member of the Institut du Droit International, as well as a member of numerous learned societies. Throughout his outstanding career, he has authored many articles, monographs, and papers in French, English, and Spanish on a wide range of topics of international law and with a particular focus on the court. In accordance with the order of precedence fixed by Article 7, Paragraph 3 of the Rules of Court, I shall first invite Judge Sima to make the solemn declaration prescribed by the statute, and I would request all those present to rise. Judge Sima, you have the floor.
Thank you, Mr. President. I solemnly declare that I will perform my duties and exercise my powers as a judge honorably, faithfully, impartially, and conscientiously.
I thank you, Judge Sima. I now invite Judge Cabral to make the solemn declaration prescribed by the statute. Judge Cabral, you have the floor.
Merci, Monsieur le Président.
Thank you, Mr. President. I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
Cabral, please be seated. I take note of the solemn declaration made by Judge Ad hoc Sima and Judge Ad hoc Cabral and declare them duly installed as a judge ad hoc in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan, Sudan versus United Arab Emirates. I shall now recall the principal steps of the procedure in the present case. On 5 March 2025, the government of Sudan filed in the registry of the court an application instituting proceedings against the United Arab Emirates with regard to a dispute concerning alleged violation by the latter of its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan, most notably in West Darfur. I shall refer to this convention as the Genocide Convention. To found the jurisdiction of the court, applicant invokes Article 36, Paragraph 1 of the Statute of the Court and Article 9 of the Genocide Convention. Together with this application, Sudan submitted a request for the indication of provisional measures pursuant to Article 41 of the Statute of the Court and Articles 73, 74, and 75 of the Rules of Court. The registrar will now read out the passage from the request, specifying the provisional measures which the government of Sudan is asking the court to indicate, pending a final judgment in the case. You have the floor, Mr. Registrar.
Thank you, Mr. President. I quote, 1. The United Arab Emirates shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Masalit in the Republic of the Sudan, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of this Convention, in particular, A. Killing members of the group, B. Causing serious bodily or mental harm to members of the group, C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D. Imposing measures intended to prevent birth within the group. 2. The United Arab Emirates shall, in relation to the members of the Masalit group, ensure that any irregular armed units which may be directed or supported by it, and any organizations and persons which may be subject to its control, direction, or influence, do not commit any acts described in point 1 above, or of conspiracy to commit genocide, of direct and public incitement to commit genocide, of attempts to commit genocide, or of complicity in genocide. End of quote.
I thank the Registrar. Immediately after the application and the request for the indication of prohibition measures were filed, the Registrar transmitted an original copy thereof to the Government of the United Arab Emirates. He also notified the Secretary General of the United Nations. According to Article 74, Paragraph 1 of the Rules of Court, a request for the indication of provision measures shall have priority over all other cases. Paragraph 2 of the same article states that the Court shall proceed to a decision on the request as a matter of urgency. This imperative must be, however, balanced with the need to fix the date of the oral proceedings in such a way as to afford the parties an opportunity of being represented at the hearings. The Court decided that these oral proceedings would be held today on 10 April 2025. By letter dated 3 April 2025, the agent of Sudan informed the Court that his government wanted to amend the measures requested in paragraph 22 of its request for the indication of provision measures, dated 5 March 2025. The Registrar will now read out the amended measures. You have the floor, Mr. Registrar.
Thank you, Mr. President. I quote, 1. The United Arab Emirates shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Masalit group in the Republic of the Sudan, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of this Convention, in particular, A. Killing members of the group, B. Causing serious bodily or mental harm to the members of the group, C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D. Imposing measures intended to prevent births within the group. 2. The United Arab Emirates shall, in accordance with its obligations under the Genocide Convention, in relation to the members of the Masalit group, refrain from any conduct amounting to complicity in the commission of any of the acts described in point 1 above, by any irregular armed units or by any organization or persons. 3. The United Arab Emirates shall submit a report to the Court on all measures taken to give effect to this order within 1 month as from the date of this order, and thereafter every 6 months until a final decision on the case is rendered by the Court. End of quote.
I would now like to welcome the delegation of the parties. I note the presence of the agents and counsel of Sudan and the United Arab Emirates. This morning, the Court will hear the single round of oral argument of Sudan, which has submitted the request for the indication of provisional measures. It will hear the single round of oral arguments of the United Arab Emirates this afternoon at 4 o'clock. Both parties have a maximum allotted time of 2 hours each for their respective oral presentations. At today's sitting, Sudan may, if required, avail itself of a short extension beyond 12 noon, in view of the time taken up by these introductory remarks. Before giving the floor to the agent of Sudan, I wish to draw the attention of the parties to Practice Direction 11, which states as follows, I quote, "In the oral pleadings on request for the indication of provisional measures, parties should limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the Court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose." End of quote. I now give the floor to the agent of Sudan, His Excellency Dr. Maiwa Osman Muhammad Khail. You have the floor, sir.
Mr. President, Madam Vice President, members of the Court, it is an honor to appear before you as the agent of the Republic of Sudan. A genocide is being committed against the ethnic group, the Masalid, in the west of our country. The Masalid are non-Arab African ethnic group. The genocide against the Masalid is being carried out by the Rapid Support Force, paramilitary Arab from Darfur, with the support and complicity of the United Arab Emirates. It was recognized during the drafting of Genocide Convention that the Commission of Genocide will, quote, nearly always involve the complicity of state, end quote. That is so in the large-scale extermination of the Masalid in the present case. The ongoing genocide would not have been possible without the complicity of the UAE, including through the continued sponsorship and shipment of arms of RSF. The UAE continues to supply the RSF with increasingly heavy arms through cargo flight to Mjaras Airport in neighboring Chad. Last year, 10,000 to 15,000 persons were killed in the RSF massacre of Masalid, population of Al Janina in West Darfur. With increased firepower and support from UAE, the RSF has now laid siege to Al-Fashir in North Darfur. Al-Fashir contains large camps from 10,000 of entirely displaced persons from the Masalid tribe. The genocide violence that will ensue if Al-Fashir now falls and the RSF take it does not bear thinking. There is an immediate risk of repeat of extermination of Masalid at Al Janina. The direct logistic and other support that the UAE has provided and continue to provide it to the RSF and their affiliated militia has been continue to be the primary driving force behind genocide now taking place, including through killing, rape, forced displacement, looting, and the destruction of public and private properties. Professor Buer will set out the fact. Mr. Warsu Kisi will address the court prima facie jurisdiction. Mr. Ogi will deal with plausibility. Then Professor Bilassi will deal with the risk of irreparable prejudice and the professional measure requested by the Sudan. Mr. President, I thank you and ask that you now invite Professor Biur to the podium.
I thank the agent of Sudan for his statement. I now invite Professor Eirik Bjørge to address the court. You have the floor.
Mr. President, members of the court, it is an honor to appear before you on behalf of the Sudan to address the facts. As I will explain, including by reference to UN sources, there can be no doubt that the Masalit people is currently being subjected to genocide, and that there is serious evidence that the UAE is failing to prevent this and is complicit. I will also deal very briefly with the existence of the dispute in case the UAE seeks to raise this as a point. It is notorious that since November 2023, the Masalit non-Arab ethnic group in the Sudan has been targeted and subjected to acts of genocide and other prohibited acts which continue to this day. The perpetrators of these acts are members of the Rapid Support Forces, the RSF, a militia comprised of Arab Darfuris, led by a former commander of the Janjaweed militia, General Mohammed Hamdan Daglo. The situation was accurately summarized as follows by the current US Secretary of State, the Honorable Marco Rubio, during his confirmation hearing before the US Congress in January of this year. By its very definition, this is a real genocide. This is the ethnic targeting of specific groups for extermination, for elimination, by groups, by the way, that are being funded by nations that we have alliances and partnerships with in other parts of the world, and we should express that clearly. I think, and part of our engagement with the UAE, and it will have to be a pragmatic engagement, I mean, they are important players in what we hope to resolve in the Middle East, and I think, as part of that engagement, we also need to raise the fact that they are openly supporting an entity that is carrying out a genocide. Against this backdrop, and in circumstances where the UAE's open support for the RSF continues, notwithstanding the fact that the RSF's ongoing siege of El Fasher is increasingly at serious risk of culminating in further acts of genocide, and the RSF's attacks against other gathering places in West and North Darfur for members of the Masalit people who have been displaced by the conflict have also escalated over the past month, the Sudan had no choice but to approach the court for urgent interim relief. It's important to understand why the current US Secretary of State felt able to express the situation in the forthright terms he used. In the spring of 2023, the RSF was increasingly capturing territory in Darfur. During clashes in El Janina in West Darfur in May-June 2023, the RSF and militias aligned with it carried out large-scale attacks on civilians, the Masalit population in particular. They conducted a systematic campaign to extirpate the city's Masalit community. The massacre by the RSF has been described as a deluge of atrocities. and a killing frenzy. Between 10,000 and 15,000 persons were killed. In this and other atrocities, the RSF has targeted gathering sites for internally displaced persons, IDPs, which have been systematically attacked, burned, and destroyed. In November 2023, the United Nations Special Advisor on the Prevention of Genocide, Alice Wairumu-Deritu, described the events in West Darfur, in the following terms: rape and other forms of sexual and gender-based violence, including sexual slavery, have been rampantly perpetrated as a weapon of war. Entire villages have been burnt, often with the plan to attack announced in advance. Derogatory and dehumanizing language, such as slaves, has been persistently used as an element of incitement to violence. Conditions of life have been deprived, with medical facilities and transportation destroyed, and access to water and electricity deliberately obstructed. This all points to risk factors for genocide. Instrumental to the RSF's prosecution of its campaign of genocide since June 2023 was its securing of new supply routes for weapons, equipment, and logistics for use in the conflict. As a result, the RSF was now able to use several types of heavy and sophisticated weapons, and these played a major role in its capture of El Jeninna. In January 2024, the UN Security Council's panel of experts on the Sudan, whose members had been appointed by a composition of the Security Council, which included the UAE itself, reported that the RSF's main supply route for arms is through eastern Chad, which borders West Darfur. The panel assessed allegations that a heavy rotation of cargo planes coming from Abu Dhabi International Airport to Amjaras Airport in eastern Chad, transporting weapons, ammunition, and medical equipment for the RSF, as well as the UAE's denial and assertions that its cargo planes had a purely humanitarian purpose. The panel concluded that the allegations against the UAE were credible. According to information gathered by the panel from sources in Chad and Darfur, the allegations were credible. Several sources in eastern Chad and Darfur, including among local native and administrative leaders and armed groups operating in those areas, reported to the panel that several times per week, weapons and ammunition shipments were unloaded from cargo planes arriving at Amjaras Airport, then loaded on trucks. Continuing to seek to operate under the cloak of humanitarianism, the UAE in September 2024 built a field hospital, emblazoned with the banner of the Red Crescent, next to the Amjaras airfield. But, tellingly, when the Red Cross sought to visit in order to understand what the UAE operation was doing under its protected banner, the officials were turned away for security reasons. The assessment of the Sudan's General Intelligence Service was that the unnatural expansion of activity in the Amjaras airport facilities, the flights to the airport, and the heavy presence of combat vehicles and military camps are not consistent with the argument that this was for the purpose of providing the needs of the field hospital. An advisor to the American NGO, the Sudan Conflict Observatory, Justin Lynch, put it this way: there is no plausible explanation for these airlifts except for weapons support to the RSF. No one is fooled. Likewise, the Sudanese General Intelligence Service has concluded that the UAE's field hospital at Amjaras Airport is the primary supply and support hub for the enemy. It has also determined that the UAE is continuing to use N'Djamena Airport in western Chad for the same purpose. The UAE, for its part, has sought to characterize such conclusions as nothing more than a duplicitous media disinformation campaign. Meanwhile, on 22nd January 2024, the European Union designated Al Junaid Multi-Activities Company under its Sudan sanctions regime. This Sudanese holding company, which had already been designated under the United Kingdom's sanction regime, is owned by Abdul Rahim Daglo, the brother of General Hamdan and his two sons. The reasons given by the European Union for the designation included a finding that the RSF is also using Al Junaid's gold production and exports to secure military support from the United Arab Emirates, UAE, to which most of Sudan's gold production is smuggled, including the provision of weapons used by the RSF in the conflict in Sudan. On 21 May 2024, the United Nations Special Advisor on the Prevention of Genocide briefed the Security Council in a meeting where the UAE was invited to participate. She took the occasion at this meeting to raise the alarm, clearly and unequivocally, about the ongoing situation in the Sudan, which bears all the marks of a risk of genocide, including strong allegations that the crime has already been committed. Civilians are far from being protected, and civilian populations are being targeted based on their identity. In Darfur and El Fasher, civilians are being attacked and killed because of the color of their skin, their ethnicity, and who they are. The Special Advisor expressed extreme concern about the attacks on the ethnic Masalit community in West Darfur, allegedly perpetrated with an explicit intent to destroy, and emphasized that the human rights and humanitarian catastrophe unfolding in the Sudan contravenes the very essence of the international obligations to prevent and punish the crime of crimes, as enshrined by the Genocide Convention, The risk of genocide exists in the Sudan. It is real, and it is growing every single day. On 5 June 2024, the Special Advisor observed in connection with El Fasher that it was unquestionable that risk factors and indicators for genocide and related crimes are present, and the risks are increasing. And on 20 September 2024, she expressed grave concern over reports that the RSF had breached the third defensive line around El Fasher, with one of El Fasher's IDP camps, Abu Shuk, teetering on the edge of disaster. Further clear evidence of the UAE's complicity emerged in the aftermath of the Battle of Jebel Moya in October 2024. The defeated RSF forces left behind arms that can only have been provided by the UAE, including ammunition crates marked United Arab Emirates, GHQ, Armed Forces, Joint Logistics Command, Postbox number 2805, Abu Dhabi, UAE. Notwithstanding its evident knowledge of the ongoing genocide, the UAE continued to supply heavy weaponry through Amjaras airport. This included the provision of sophisticated drones that were increasingly flown out of Amjaras and into the Sudan. Moreover, the UAE has also assisted and aided the RSF in the recruitment of mercenaries to support the attack against El Fasher. On 20 November 2024, a joint military force was engaged in an operation near to where North Darfur borders Libya. After a firefight, the mission was able to collect the passports of certain of the foreign mercenaries. Among them were Colombian nationals whose passports contained entry visas from the UAE from the previous month. As the Wall Street Journal reported, the Colombian mercenaries were hired by an Abu Dhabi-based company called Global Security Services Group, which has presented itself as acting on behalf of the Emirati government. North African officials interviewed by the Wall Street Journal put the number of Colombian mercenaries who have been sent to the Sudan at approximately 160. A detailed Colombian investigation put it at 300. On 7 January 2025, after careful review of the facts and a comprehensive legal analysis, the US Secretary of State correctly determined that a genocide was being committed in the Sudan, stating that the RSF and RSF-aligned militias have continued to direct attacks against civilians. The RSF and allied militias have systematically murdered men and boys, even infants, on an ethnic basis, and deliberately targeted women and girls from certain ethnic groups for rape and other forms of brutal sexual violence. Those same militias have targeted fleeing civilians, murdering innocent people escaping conflict, and prevented remaining civilians from accessing life-saving supplies. Based on this information, I have now concluded that members of the RSF and allied militias have committed genocide in Sudan. On the basis of this determination, the United States sanctioned RSF's commander, General Hamdan, for his role in systematic atrocities, It also sanctioned 7 companies owned by the RSF, as well as 1 individual for their role in procuring weapons for the militia. They were, all of them, based in the UAE. The UAE Ministry of Justice waited for around 4 months before it responded on 4 April 2025, only after the Sudan had submitted this dispute to the court. And even then, the UAE used notably circumspect language, asserting that none of the 7 entities hold an active business license in the UAE, nor are they currently operating in the UAE. Against this backdrop, as you have seen, the current US Secretary of State felt compelled in January 2025 not only to recognize the existence of the ongoing genocide, but also to call out the UAE for its open support of the entity that is carrying out that genocide. Since that date, the plight of the surviving members of the Masalit group in North and West Darfur has only become more desperate. There are thousands of Masalit in North Darfur, particularly in El Fasher and in Zamzam camp, many of them internally displaced. The RSF is currently mobilizing even greater forces and intensifying its attacks with the aim of breaking the siege of El Fasher, which has been ongoing since May 2024. So important is the taking of El Fasher to the RSF and its sponsor that the UAE is reported in recent months to have intensified its efforts of support in order to ensure that El Fasher falls. If that happens, everything points to a repeat of the atrocities of El Janina. At the same time, the RSF has been attacking gathering sites where there are internally displaced members of the Masalit group, including Zamzam camp. Between 9 and 13 February 2025, following heavy artillery shelling, the RSF launched a ground assault against the camp and raised its main market in arson attacks. The Humanitarian Research Lab of the Yale School of Public Health confirmed on 13 December 2024 the large-scale displacement of an unknown number of civilians from Zamzam IDP camp following repeated heavy artillery bombardment over 12 days by the RSF. It also identified and located 4 heavy artillery pieces, consistent with a type of Chinese-produced 155mm howitzer artillery gun, which it considered were engaged in the bombardment of Zamzam. Yale's Humanitarian Research Lab noted, on the basis of publicly available sources, that the UAE was the only country known to have purchased this type of howitzer. Notably, the Security Council's panel of experts had reported earlier that the increasingly heavy weaponry provided by the UAE included howitzers, and that these had been observed in El Fasher. The assessment of the Sudan is that the howitzers in question, of which there were 11 in total, arrived by UAE aircraft which landed at Amjaras Airport on 1 October 2024 and were transported onwards by truck into Darfur before they were put to use by the RSF. And yet, the nightly weapons and ammunition flights from the UAE into inter alia Amjaras airfield continue to arrive. Sudan's own intelligence assessment in March 2025 is that the flights to Chadian airports transporting military aid to the RSF have continued to the present. To conclude, there can, for present purposes, be no question that there is sufficient evidence that the UAE is not only failing to prevent genocide, but is also complicit in genocide. This will, of course, be the subject of full argument at the merits stage, although direct proof will, to a large extent, continue to rest in the hands of the UAE itself. For present purposes, it is relevant to recall the court's observation in Corfu Channel, that in such a situation, the other state, the victim of the breach of international law, in this case the Sudan, should be allowed a more liberal recourse to inferences of fact and circumstantial evidence. Here, the Sudan has presented a series of facts linked together and leading logically to a single conclusion. Finally, it cannot seriously be argued that the UAE was unaware of the existence of this dispute prior to the filing of the Sudan's application. I can be brief. First, in a letter to the President of the Security Council dated 26 April 2024, the Sudan stated that the support of the United Arab Emirates for the criminal Rapid Support Forces militia, which has waged war against the state and its citizens, makes the United Arab Emirates a partner in all the crimes and atrocities that this militia has committed. The Sudan demanded that the UAE be held responsible for crimes including crimes amounting to genocide. Second, during the Security Council meeting held on 18 June 2024, the Sudan stated that the Security Council must identify by name the state sponsoring that plague which is subjecting the people of the Sudan to gradual genocide. The Sudan concluded, the United Arab Emirates is a country that is sponsoring systematic and ethnically based terrorism in the Sudan. The Rapid Support Forces are supported, sponsored, and incited by the United Arab Emirates to fight in the Sudan and perpetrate crimes and rapes. In the same meeting, the UAE denied all of this as false. Third, during the Security Council meeting held on 11 September 2024, the Sudan stated that the United Arab Emirates fuels the war and supports the militia that has committed the crime of genocide. Fourth, in a press release dated 12 February 2025, the Sudan stated that the RSF, backed by its regional sponsor, is escalating its campaign of genocide against the majority of Darfur's population. The terrorist militia has been waging a brutal ongoing attack on the Zamzam camp for internally displaced persons. It further stated that the RSF targeted internally displaced persons on an ethnic basis. The press release concluded that the militia's regional sponsor bears direct responsibility for ongoing genocide. That, Mr. President, members of the court, concludes my presentation. I ask that you invite Mr. Wordsworth, KC, to the podium to address prima facie jurisdiction.
I thank Professor Bioga for his statement. I now call Mr. Samuel Wordsworth to the podium. Sir.
Mr. President, members of the Court, it's a privilege to appear before you and to have been asked by Sudan to address the issue of the Court's prima facie jurisdiction. The question is whether Article 9 of the Genocide Convention, which is of course well known to the Court and is now on the screen, appears prima facie to afford a basis on which its jurisdiction could be founded. Both Sudan and the UAE are parties to the Convention. Sudan acceded on 13th October 2003 without entering any reservation. The UAE acceded on 11th November 2005, subject, as the Court will be aware, to a reservation with respect to Article 9. Where an applicant invokes a compromissory clause, such as Article 9, the Court must ascertain whether the acts complained of by the applicant are prima facie capable of falling within the provisions of that instrument, and whether, as a consequence, the dispute is one which the Court could have jurisdiction ratione materiae to entertain. As to this, the acts of which Sudan complains plainly are capable of falling within the scope of the substantive provisions of the Genocide Convention, and there is a dispute as to the UAE's compliance with the Convention as just outlined by Professor Bjorga. Turning to the reservation, the UAE's instrument of accession to the Genocide Convention states in relevant part that it makes a reservation with respect to Article 9 thereof concerning the submission of disputes arising between the contracting parties relating to the interpretation, application or fulfilment of this convention to the International Court of Justice at the request of any of the parties to the dispute. Now, where at a provisional measures phase a respondent invokes a reservation entered in relation to the compromissory clause, two separate questions arise. First, the Court must examine the reservation and assess whether it is capable, prima facie, of being correctly interpreted so as not to deprive the Court of jurisdiction. That is a question of interpretation. The second question arises if, and only if, the Court decides that the reservation can only be interpreted so as to exclude jurisdiction. This second question, of course, goes to validity. Is the reservation capable, prima facie, of being found to be invalid? That is, at the appropriate later stage in the proceedings and after hearing full argument. I deal with these two separate questions in turn. However, as to both, it is useful to recall the observation of Judge Greenwood in his separate opinion in the Georgia and Russia case. Requests for the indication of provisional measures of protection are considered as a matter of urgency, without the opportunity for the consideration of extensive evidence or the detailed analysis of legal issues which can be undertaken in later phases of the proceedings. The jurisdictional threshold which the applicant has to cross is accordingly set quite low, and any ruling, whether as to law or fact, which the Court makes at the provisional measures stage of a case is necessarily provisional. Consistent with the quite low threshold that is applied in light of the urgency and the inability to hear full argument, the Court has generally refrained from determining disputed questions of interpretation at the provisional measures stage, reserving these to the appropriate later stage. Of particular relevance, so far as concerns reservations, at the provisional measures stage of the nuclear tests case, France argued that the dispute fell within the exclusion from its acceptance of compulsory jurisdiction of disputes concerning activities connected with national defence. New Zealand contested this and maintained that the validity, interpretation and effect in the present situation of the reservation attached to the French Declaration are issues which can be the subject of debate, that is, at a later stage, with there being various arguments in favour of the court's jurisdiction. In these circumstances, the court refrained from making any pronouncement on the interpretation or validity of the reservation and concluded that at the present stage of the proceedings, the provisions invoked by the applicant appear prima facie to afford a basis on which the jurisdiction of the court might be founded. And the court then went on to indicate provisional measures. Turning then to the first question, that is the interpretation of the UAE's reservation. This is capable, and a fortiori capable prima facie, of being interpreted so as not to deprive the court of jurisdiction under Article 11. The principles governing the interpretation of reservations are unlikely to be an issue today. In its guide to reservations, the ILC stated that a reservation is to be interpreted in good faith, taking into account the intention of its author as reflected primarily in the text of the reservation, as well as the object and purpose of the treaty and the circumstances in which the reservation was formulated. Of course, any state making a reservation can be expected to have given very careful consideration to the specific formulation of the words it chooses to use. In this respect, unlike in the context of treaty drafting, there is no question of compromise or negotiation with other parties. Focusing then on the text of the UAE reservation, this is notably vague and non-specific. It merely makes a reservation with respect to Article 9, with no wording of any kind specifying the content and nature of that reservation. The rest of the reservation then reflects the wording of Article 9, what it concerns, l'article selon lequel in the French text. Notably, however, what follows omits the key wording on the responsibility of a state for genocide. And as the court recognized in the Bosnian genocide case, the fact that Article 9 confers jurisdictions over disputes, including those relating to the responsibility of a state for genocide, is an unusual feature of the wording of Article 9. Equally to the point, it is precisely the responsibility of a state for genocide in respect of which the court's jurisdiction is engaged in the current case, including as to the state's complicity in genocide. Now, no other state has entered such a vague and non-specific reservation to the Genocide Convention, which, moreover, omits this key wording. Compare, for example, the US reservation of 27th November 1988, which this court considered in its order of 5th June 2023 in Ukraine and Russia. This reads, with reference to Article 9 of the Convention, before any dispute to which the United States is a party may be submitted to the jurisdiction of the International Court of Justice under this article, the specific consent of the United States is required in each case. Although the UAE reservation came many years later than this, the clear US wording to the effect that specific consent is needed to establish jurisdiction was not adopted. And it was by virtue of this clear wording that the court was able to find in Ukraine and Russia that the United States is not bound by Article 9 of the Convention. Although, to note, this was in a context where, unlike here, there was no issue as to whether the reservation was capable of any other interpretation. Compare as a second example the 1975 reservation of Rwanda under consideration in the DRC and Rwanda case in 2002. The Rwandese Republic does not consider itself as bound by Article 9 of the Genocide Convention. Again, the UAE elected not to adopt this seemingly clear wording, although that wording was well known to have been the subject of an order of the court at the time that the UAE was formulating its reservation. And note in passing, again, unlike here, the DRC made no submission at the provisional measures phase, or indeed subsequently, that Rwanda's reservation was capable of being interpreted other than as excluding the court's jurisdiction under Article 9. Instead, it challenged the validity of the reservation. That is, an entirely separate matter that I'll be returning to a little later. So looking just at the text, it is quite unclear what the intent of the UAE reservation is. In what respect does it seek to exclude or perhaps modify the effects of Article 9? It might be to require a further consent. It might be to require some preconditions to the season of the court, such as negotiation. It might be intended as a statement that the UAE does not consider itself bound by Article 9, save for when its own state responsibility is directly in issue. And taking into account the circumstances in which the reservation was formulated, as per the ILC guide, the obvious point is that the UAE appears to have elected not to have adopted well-known examples of text through which other states have sought in unambiguous terms to reject compulsory jurisdiction under Article 9. Now, the text must also be interpreted taking into account the object and purpose of the treaty. And this is a crucial point. In considering the object and purpose of the Genocide Convention, the Court said in its 1951 advisory opinion, the Convention was manifestly adopted for a purely humanitarian and civilizing purpose. It is indeed difficult to imagine a convention that might have this dual character to a greater degree, since its object, on the one hand, is to safeguard the very existence of certain human groups, and on the other, to confirm and endorse the most elementary principles of morality. In such a convention, the contracting states do not have any interests of their own. They merely have, one and all, a common interest, namely the accomplishment of those high purposes which are the raison d'etre of the convention. Of course, the court was then considering the question of whether reservations would be incompatible with the object and purpose of the convention. The issue it again considered in the DRC and Rwanda case in relation to Rwanda's unambiguous reservation. But at this stage of Sudan's argument, the issue is only as to what may be a prima facie correct interpretation of the specific UAE reservation. The relevant backdrop, then, is that the convention aims to safeguard the very existence of certain human groups and to confirm and endorse the most elementary principles of morality, while the UAE has unquestionably an interest in the accomplishment of those high purposes. Against this backdrop, the court must consider whether the UAE's notably elliptical reservation is intended to exclude jurisdiction over its own state responsibility for genocide, despite the apparently careful omission of those very words from its reservation. Sudan says this cannot be the case. Or, more to the point, for current purposes, that at least prima facie the UAE reservation is capable of being interpreted other than as a statement that the UAE does not consider itself bound by Article 9 with respect to the issues of state responsibility that are now before you. The Court should not, and indeed cannot, at this very early stage, conclude on the elliptical wording of the UAE reservation that, to borrow the words of the joint separate opinion of the 5 judges in the DRC and Rwanda case, when they were considering object and purpose, that the UAE wished to be in a position to shield from international judicial scrutiny any claim that might be made against it concerning genocide, and likewise wished to show the world scant confidence that it would never ever commit genocide, one of the greatest crimes known. The UAE reservation is plainly capable of being interpreted other than as a display of such scant confidence. For example, it can be interpreted as a declaration that in general terms it does not consider itself bound, but subject always to a claim where its own responsibility for genocide, including its own complicity, is directly at issue. In short, there is a notable absence of the clear and unambiguous language that might require the Court to conclude at this stage that the reservation is incapable, at least prima facie, of being interpreted other than as an exclusion of the Court's jurisdiction. And please note, the current case is very different from that before the Court in the 2 legality of use of force cases brought by Yugoslavia against Spain and the United States. In its orders of 2nd June 1999, very exceptionally, the Court did conclusively interpret reservations made by the respondents. It concluded that there was a lack of prima facie jurisdiction and, in addition, a manifest absence of jurisdiction, such that it was appropriate to strike those cases from the general list. However, those were very different cases. 3 points. First, as the Court expressly recorded in both orders, Yugoslavia disputed the interpretation of the Genocide Convention, but submitted no argument concerning the reservation to Article 9 of the Convention. Thus, these are not examples of how the Court has dealt with the disputed interpretation of a reservation at the provisional measures stage. Second, the absence of any argument as to interpretation is understandable, because both of the reservations then at issue could be taken as unambiguously excluding the Court's compulsory jurisdiction under Article 9. You've already seen the US reservation. Spain's reservation, which was withdrawn in 2009, was stated to be in respect of the whole of Article 9, brackets, jurisdiction of the ICJ, close brackets, full stop. That is, with no notably incomplete description of the provision then following. Third, the Court was faced with factual allegations concerning NATO's aerial military operations that were in no way even prima facie capable of constituting acts of genocide. So this was a very natural case for rejecting jurisdiction under the Convention wherever feasible. And the UAE's reservation to the Convention is not just very differently worded to that of the USA and Rwanda and the one-time reservation of Spain, it is materially different to that of any other state, as you can see in due course from the text of the other reservations which are in your judge's folder at tab 21. And to recall, when the UAE formulated its reservation in 2005, it was well aware that over the previous decades, many other states had adopted clear and unambiguous wording, and yet it elected not to follow such models. Nonetheless, the UAE will presumably now ask the court to approach its uniquely worded reservation as if it were incapable, even prima facie, of being interpreted other than as excluding jurisdiction under Article 9. But that would be nothing more than an attempt to rewrite the terms of the reservation some 20 years after the event. Stepping back, it is recalled that the object of the Convention is to safeguard the very existence of certain human groups. Through Article 9, this court plays a pivotal role in giving practical effect to the realization of that object. That role is all the more important where, at a provisional measures phase, there is strong evidence of state responsibility in relation to an ongoing genocide, and the court is called upon to act in safeguarding the very existence of a protected group. That, in an exercise of its prima facie jurisdiction, the court may consider to be at real and immediate risk of genocide. Surely, that critical role could not be defeated by an ambiguously worded reservation such as now before you that is capable of being interpreted, at least prima facie, in a way consistent with the exercise by this court of its jurisdiction under Article 9. I turn to the second question, which concerns the validity of the UAE reservation, and which is only engaged if the court does not accept that the reservation is prima facie capable of interpretation along the lines I've just outlined. In those circumstances, the court will still have jurisdiction prima facie if it is satisfied that the reservation is capable prima facie of being held to be incompatible with the object and purpose of the Convention and hence invalid. In its guide to practice on reservations, the ILC has reflected the distinction between the essential clauses of a treaty, in respect of which reservations cannot be admitted, and the less important clauses, in respect of which reservations may be admitted. As then President Awada suggested in his 2010 remarks to UN member state legal advisers, arguably Article 9 of the Genocide Convention provides an example of a dispute settlement clause which might be considered to constitute part of the raison d'etre of the treaty. Sudan considers that Article 9 does provide such an example, and not merely as a matter of what would be reasonably arguable, which would, however, be sufficient for the present purposes of jurisdiction prima facie. Sudan, of course, recognises that approaching 20 years ago, in its 2006 judgment in DRC and Rwanda, the court stated that in the present circumstances of the present case, the court cannot conclude that the reservation of Rwanda in question, which is meant to exclude a particular method of settling a dispute, as to the interpretation, application or fulfilment of the Convention, is to be regarded as being incompatible with the object and purpose of the Convention. As the careful language makes clear, the court was concerned with the specific reservation and case before it. As emphasised in the separate opinion of 5 judges, the court made no more generalised finding. I wish to look first at the court's judgment, then turn to look further at the joint separate opinion, and finally to say a few words on the absence of any objection by Sudan to the UAE reservation, in case something is made of that fact later today. In the 2006 judgment, the court gave just 3 brief reasons for its conclusion, and it's to be recalled that the court was faced with a scattergun claim in which the DRC invoked some 11 sources of jurisdiction. First, the court observed that Rwanda's reservation to Article 9 of the Genocide Convention bears on the jurisdiction of the court and does not affect substantive obligations relating to acts of genocide themselves under that convention. Well, this is true from one perspective, but it does not answer the key question of whether the exclusion of jurisdiction is incompatible with object and purpose, in particular, given that the court's jurisdiction is vital to the enforcement of the Convention's substantive obligations. After all, the Genocide Convention is unique among the human rights conventions in allowing for and depending upon immediate direct access to the court as the sole available international judicial forum in circumstances where there is no treaty body for the supervision of performance by states parties. Second, the court recalled that it had previously given effect to the reservations at issue in the legality of use of force cases. However, as you've already seen, Yugoslavia submitted no argument on the reservations then at issue, whether as to their invalidity or otherwise. Third, as in legality of use of force, the court noted that Congo had not objected to Rwanda's reservation. I'll be returning to that issue shortly. But the point for now is that plainly and unsurprisingly, the court did not see this as providing some form of definitive answer on invalidity. Had it been otherwise, the court could readily have just accepted the point on no objection and not troubled itself with the broader issues on invalidity. I turn to the joint separate opinion. Given the number and identity of the judges and the force of the reasoning, the 2006 judgment must be considered alongside this important opinion and its conclusion that it is not self-evident that a reservation to Article 9 could not be regarded as incompatible with the object and purpose of the Convention. And we believe that this is a matter that the court should revisit for further consideration. In this respect, the opinion noted that in its 1951 advisory opinion, the court was not asked to pronounce on the compatibility of particular reservations to the Genocide Convention with its object and purpose, and nor did the court foreclose legal developments in respect of hitherto uncharted waters in the future. It was also noted by the 5 judges, and the court already has this point, that in legality of use of force, Yugoslavia had not made any argument that the reservations were contrary to the object and purpose of the Convention, so the court did not consider or pronounce on that issue. Did not pronounce on that issue, I apologise. The joint separate opinion also raised specific elements of concern about 3 matters absent from the court's reasoning. First, it was emphasised that the court, although not a monitoring body, does have an important role under the Genocide Convention. Under that convention, it is states who are the monitors of each other's compliance with prohibition on genocide. Article 9 then gives a state who believes another state is committing genocide the chance to come to the court. Second, it was noted that Article 9 speaks not only of disputes over the interpretation and application of the Convention, but over the fulfilment of the Convention. Indeed, the inclusion of this term is another unique feature of Article 9 among compromissory clauses in conventions concerning human rights. Then, as a final and third element, further, the disputes that may be referred to the court under Article 9 include those relating to the responsibility of a state for genocide, although, of course, the UAE does not include this unusual feature in its reservation. Looking at these 3 elements of concern, Sudan agrees with South Africa's recent submission before the court that the role of the court, which unusually extends not only to the interpretation and application of the Convention, but also to its fulfilment, is pivotal. In addition to their substantive obligations under the Convention, it is vitally important that states respect the court and their procedural obligations. And the recent jurisprudence of the court, both in Gambia and Myanmar, and now in the order of 26 January 2024 in South Africa and Israel, contains some recognition of this in finding that there is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on states parties thereto, and the right of any state party to seek compliance therewith by another state party. That must be correct. And the recognition of that correlation supports the view that Article 9, which is the key tool in seeking compliance, should be considered to constitute part of the raison d'etre of the treaty. That position is also supported by the travaux to the Convention, which again did not feature in the argument in 2006 and which the court's judgment did not consider. The travaux showed that it was well understood that the court would play an important role in connection specifically with prevention of genocide, for it alone was competent to decide whether or not a state was guilty of violating the terms of the Convention and to determine the necessary legal redress. The court could in fact contribute in no mean degree, and in the French that is dans une large mesure, to the prevention of genocide. The court should also be aware of relevant state practice, which again was not before the court in 2006 and did not feature in the 2006 judgment. Of course, there's no time for a detailed consideration at this stage, but 12 states had withdrawn their reservations, excluding jurisdiction under Article 9, and a number of other states had objected to such reservations. This included the Netherlands, Croatia, Norway, Brazil, and Mexico, which had expressly characterized such reservations as incompatible with the object and purpose of the Convention. So finally then, a few words on the legal relevance of the fact that Sudan did not lodge an objection to the UAE reservation. And the short answer, for the purposes of these proceedings, is that it has no legal relevance. The absence of objection did not in 2006 and does not now preclude the court from considering whether a reservation is, or prima facie could be, incompatible with the object and purpose of the Convention, as is required by Article 19C of the Vienna Convention on the Law of Treaties. Nor does it impact on Sudan's ability to contest the validity of the reservation before you. The rule on making an objection to a reservation within 1 year, which is to be found at Article 20 sub 5 of the Vienna Convention, has nothing to do with the substantive validity of the reservation, which is the subject matter of Article 19 of the Vienna Convention. And it would be bizarre if it were otherwise. Read in context, Article 20 sub 5 can only be concerned with objections to reservations to the extent they are valid. The point can be seen clearly from paragraph 4.5.2 of the ILC guide and the related commentary. This states that the nullity of an invalid reservation does not depend on the objection or the acceptance by a contracting state or a contracting organisation. Nevertheless, a state or an international organisation which considers that the reservation is invalid should, if it deems it appropriate, formulate a reasoned objection as soon as possible. As the commentary then explains, as established above, the Vienna Conventions do not contain any rule concerning the effects of reservations that do not meet the conditions of permissibility set out in Article 19, or, as a logical consequence thereof, concerning the potential reactions of states to such reservations. Under the Vienna regime, an objection is not an instrument by which contracting states or organisations assess the validity of a reservation. Rather, it renders the reservation inapplicable as against the author of that objection. The acceptances and objections mentioned in Article 20 concern only valid reservations. The mere fact that these same instruments are used in state practice to react to invalid reservations does not mean that these reactions produce the same effects or that they are subject to the same conditions as objections to valid reservations. So if the UAE seeks to rely on the absence of objection by Sudan, this is a non-point. In any event, because the UAE reservation was capable of being interpreted as not excluding jurisdiction, it did not call out for objection. Notably, the United Kingdom, which has had a long-standing policy of objecting to clear and unambiguous reservations excluding jurisdiction, did not object to the UAE's reservation, and nor did any of the other 10 states which have made such objections, namely Australia, Belgium, Brazil, Croatia, Ecuador, Greece, Mexico, the Netherlands, Norway, and Sri Lanka. As to the 2006 judgment more generally when it comes to validity, although this of course commands considerable respect from Sudan, it does not provide the answer to the issue before you today. the various elements of concern raised in the joint separate opinion, alongside the other matters Sudan has raised, demonstrate that if the UAE reservation could only be interpreted so as to bar jurisdiction, which, as you have seen, is not the case, it is capable, at least prima facie, of being held to be incompatible with the object and purpose of the Convention and hence invalid. I thank you for your attention and ask you, Mr. President, to hand the floor to Hague, who will be addressing you on the plausible rights of Sudan.
I thank Mr. Wadsworth for his statement, and I invite Mr. Janoki to address the court. You have the floor, sir.
Mr. President, members of the court, it is a privilege to appear before you and to have been asked by Sudan to address the issue of plausibility. At this stage of the proceedings, the court is of course not required to determine definitively whether the rights which Sudan wishes to see protected exist. Rather, the court need only be satisfied that the rights claimed by Sudan and for which it is seeking protection are plausible. The right claimed must be merely grounded in a possible interpretation of the Convention. Plainly, the rights Sudan is seeking to protect are at least plausible. They are not merely grounded in a possible interpretation of the Genocide Convention, but in an interpretation that reflects the court's own previous findings. Sudan is requesting provisional measures to protect its rights to seek the UAE's compliance with its obligations to take actions to prevent breaches of the Genocide Convention occurring on Sudan's territory and to refrain from complicity in such breaches. The UAE freely undertook such obligations when it acceded to the Genocide Convention. In its application, Sudan also claims that the UAE is responsible for acts of genocide committed by irregular armed units over which the UAE exercises direction and control. This will be an important issue for full argument at the merits stage, but it is not one that arises for consideration today. In its 1951 advisory opinion, referring to the special characteristics of the Genocide Convention, the court emphasized that it was the intention of the United Nations to condemn and punish genocide as a crime under international law involving the denial of the right of existence of entire human groups. The rights of the Muslim human group to be protected from acts of genocide and related prohibited acts under Article 3 are beyond doubt. The Muslim are a distinct African, non-Arab ethnic group, and hence a protected group within the meaning of Article 2 of the Convention, which is on the screen. I start then with Sudan's right to seek the UAE's compliance with its obligation of prevention under Article 1 of the Convention. In the Bosnia genocide case, the court held that state parties are under a due diligence obligation to employ all means reasonably available to them so as to prevent genocide so far as possible. The court explained, a state's obligation to prevent and the corresponding duty to act arises at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to it means likely to have a deterrent effect on those suspected of preparing preparing genocide or reasonably suspected of harbouring specific intent, dolus specialis, it is under a duty to make such use of these means as the circumstances permit. Here, the UAE's obligation of prevention was undoubtedly engaged at least as early as November 2023. By that time, as you have heard, UN sources were already sounding a clear alarm about the risk of genocide. And by May 2024, the Special Advisor was informing the Security Council that the ongoing situation in the Sudan bears all the marks of a risk of genocide, including strong allegations that the crime has already been committed. And in June 2024, she specifically identified the increasing risk of genocide in El Fasher. Now, although a breach of the obligation of prevention can result from omission alone, the breach is all the more evident here because the UAE has been positively supporting the actors committing genocide by supplying them with funds, equipment, and weapons to be used in the conflict. As you have heard from Professor Bjorge, UN sources have assessed that there are at least credible allegations of this. And the European Union has gone further still in designating a Sudanese gold company that is owned and controlled by General Hamdan and his family on the ground that it is used to secure military support from the UAE, including the provision of weapons used by the RSF in the conflict in Sudan. Moreover, the UAE is not only a geographically close state with strategic interests in Sudan, but one that has very close links with the senior leadership of the RSF and a real capacity to influence their conduct. 3 illustrative examples of such links. First, in December 2023, General Hamdan was photographed at Entebbe Airport disembarking from an aircraft belonging to Royal Jet, a UAE charter airline run by an advisor to the President of the UAE. And flight records show that that aircraft had flown from Abu Dhabi. Second, General Hamdan's youngest brother has lived in Dubai since 2014, where he established companies to manage the family interest in marketing gold sourced from Sudan. Third, as you've already heard from Professor Bjorge, the United States has sanctioned 1 individual and 7 entities located in the UAE for their support to the RSF. And in light of all this, there is every reason to view as at least plausible press reports stating that General Hamdan has very recently travelled to the UAE to meet with senior UAE officials and to discuss the potential reorganisation of the RSF following the government's liberation of Khartoum. I turn now to Sudan's right to seek compliance from the UAE in refraining from complicity in genocide. In its 2007 judgment in Bosnia genocide, the court held that there is no doubt that complicity, in the sense of Article 3, paragraph E of the Convention, includes the provision of means to enable or facilitate the commission of the crime. The court explained, although complicity as such is not a notion which exists in the current terminology of the law of international responsibility, it is similar to a category found among the customary rules constituting the law of state responsibility, that of the aid or assistance furnished by one state for the commission of a wrongful act by another state. The Court also recognised that in this connection, reference should be made to Article 16 of the ILC's Articles on State Responsibility, reflecting a customary rule. This states as follows: a state which aids or assists another state in the commission of an internationally wrongful act by the latter is internationally responsible for doing so if that state does so with the knowledge of the circumstances of the internationally wrongful act, and that act would be internationally wrongful if committed by that state. The Court found that it could see no reason to make any distinction of substance between complicity in genocide, within the meaning of Article 3, paragraph E of the Convention, and the aid or assistance of a state in the commission of a wrongful act by another state within the meaning of Article 16. Plainly, there is at least a plausible case that Sudan has rights under Article 16. I have already addressed the question of the UAE's knowledge of the genocide from November 2023, and there can, of course, be no dispute that those heinous acts would be internationally wrongful if committed by the UAE itself. Notwithstanding its knowledge that the RSF was committing acts of genocide, the UAE continued, and indeed continues still, to lend aid and assistance to the RSF, including through the provision of weapons and equipment to be used in the conflict. Some of those weapons have no doubt already been, and very likely will be, used to commit atrocities against the surviving Masalit group in North and West Darfur, including the tens of thousands currently under siege in El Fasher and in other gathering places, such as the Zamzam camp. I thank you for your attention. Mr. President, I ask you to call to the podium Professor Palchetti, who will address urgency and irreparable harm.
I thank Mr. Oji for his statement. I now invite Professor Paolo Palchetti to the podium. Sir.
President, distinguished judges, it is an honor for me to represent the Republic of Sudan before you. It is my task, first of all, to demonstrate that the conditions of urgency and the risk of irreparable harm are met in the present case. I will then present the measures requested by Sudan. When a case involves a violation of the Genocide Convention, it becomes necessary to dwell on the irreparable nature of the harm that could be caused to the rights in dispute. Your jurisprudence is clear on this point. As you have stated, the rights of a group to be protected against acts of genocide are, and I quote, of such a nature that the harm caused to them could be irreparable. And again I will quote, in light of the fundamental values that the Genocide Convention seeks to protect. End of quote. The rights at stake in our case are not merely threatened by a risk of irreparable harm. This risk is real and imminent. The condition of urgency is therefore fulfilled. The Masalit group in Sudan continues to be exposed to a situation of extreme vulnerability today. Its right to be protected against acts of genocide is at risk of suffering irreparable harm at any moment. This real and imminent risk to the Masalit group is not solely attributable to the rapid support forces and allied militias. Through their actions, In the conflict ravaging Sudan, the United Arab Emirates have greatly contributed to making this situation possible and continue to do so. To the extent that the UAE continues to provide active support to the rebel forces responsible for this situation, in flagrant violation of their obligations to prevent genocide and to not provide aid or assistance in the commission of genocide, the real and imminent risk facing the Masalit group is also attributable to the Emirates. This justifies the urgent measures that Sudan requests the court to indicate, and all means should be used to bring an end to this genocide. My colleagues who preceded me have already presented to you the multiple sources attesting to the acts of genocide committed against the Masalit group, as well as the assistance provided by the United Arab Emirates to the forces responsible for these genocidal acts. I return to these 2 points in order to emphasize that this situation persists today and require indicative measures in the face of a situation where new acts of genocide may be committed at any moment. Mr. President, the existence of a risk of genocide has been known since the end of 2023. As early as November 2023, the High Representative of the European Union condemned the massacre of more than 1,000 members of the Masalit community and called upon the international community to ensure that another genocide does not occur in Darfur. The situation has not changed in 2024. The existence of a risk of genocide has continued to be denounced, including by the United Nations Special Advisor on the Prevention of Genocide. On 19 December 2024, the Senior Advisor to the Organization Preventing and Ending Mass Atrocities, Mrs. Shania Lewis, clearly denounced the existing situation before the UN Security Council in regard to what was happening in Sudan. It is worth revisiting what she said before the Security Council just a few months ago. The atrocities committed by the Rapid Support Forces extend across the entire country. These forces, supported by the United Arab Emirates, are committing genocide in Darfur, from Ardamata to Jenaina, and from Khartoum to El Fasher. And today, they are carrying out ethnic cleansing in Zamzam, the largest displacement camp in Sudan, which is plagued by famine. The Rapid Support Forces are attempting to complete the genocide that began more than 20 years ago, and they are succeeding in doing so. At the beginning of 2025, the United States also recognized, and I quote, that members of the RSF and allied militias have perpetrated genocide in Sudan. In recent weeks, the situation has continued to worsen. In a report presented to the Security Council at the end of February 2025, the United Nations Secretary General stated that violence against civilians has further intensified, particularly in the Zamzam displacement camp. Professor Bjorg already spoke to you about the siege that cities have been subjected to since time back. At the beginning, the spokesman for the United Nations underscored the humanitarian catastrophe that has affected the city, and I quote him. He says, "We are greatly alarmed."
Hostilities in and around El Fasher in North Darfur state, including attacks in the past 2 days that resulted in civilian casualties. Fin de citation. La presse la plus réputée par...
The press has subsequently commented that an unprecedented catastrophic situation in the city of El Fasher has arisen. The city of El Fasher and the Zamzam camp are host to thousands of people who belong to the Masalit community. The urgency that presently characterizes the situation in Darfur and therefore not be subject to any doubt. A genocide is indeed being committed, and new acts of genocide can occur at any moment. This said, in spite of the cries of alarm put forward by the international community, is a state that continues to arm the militias committing this genocide, and this state, through its action, through its omission, has made it possible and continues making it possible for this situation to continue. You have already been informed about cargo planes flying between the Emirates and Darfur and transporting arms and ammunitions. Sudan has also provided the court with an intelligence report describing in a detailed manner the specific dates and times of arrival of how these flights have been organized to supply weapons to the rapid support forces. This afternoon, the United Arab Emirates will likely protest against Sudan's allegations. They will tell you that, yes, there are frequent flights between the United Arab Emirates and Chad, but that these flights only carry humanitarian aid. It will then be important to remember that as early as January 2024, the Sudan Expert Group established by the Security Council concluded that Sudan's allegations, I quote, are credible, end of quote. According to the expert non-governmental group, the information published in the press further confirms the allegations made by Sudan. It further confirms that the delivery of weapons has never ceased. And I would like to say in passing that the legitimacy of these sources cannot be contested because they fully satisfy the requirement of consistency and congruence that you require to base the proof of a fact on such documents. In a report from November 2024, the International Crisis Group, an independent, non-governmental institute whose reports are based on information and assessments gathered on the ground, to use your own words, confirms that arms deliveries have continued without interruption. The modalities are the same as those described in the UN report. Emirati cargo planes have nonetheless landed regularly in Chad, first at Amjaras, Enedi East province in the northeast of the country, and then in Jamena, after turning off their transponders in order to avoid being tracked. The weapons are then transported to Darfur by road. The intelligence report presented by Sudan indicates that arms deliveries continue even today. This is confirmed by information from the press, which also attests to an intensification of cargo plane arrivals from the Emirates to N'Djamena. These flights in April 2025, as well as 11 February and 3 flights on the 12th. This situation is described as a nocturnal ballet of aircraft. Mr. President, the delivery of weapons is only one of the modalities whereby the United Arab Emirates has facilitated the genocide against the Masalit community. And it is nevertheless sufficient in order to prove the extent to which the present behavior of the Emirates continues to the situation of extreme vulnerability to which the Masalit community is exposed. it is urgent that they ceased in the assistance of commission of a genocide in Sudan, and this is what justifies the indicative provisional measures requested by Sudan and that I will now present. As Council Oke indicated to you, the rights that Sudan seeks to have protected are those derived from the obligations incumbent upon the United Arab Emirates under Articles 1 and 3 of the Genocide Convention, namely the obligation to prevent genocide and the obligation not to commit or engage in acts that constitute complicity in genocide. The first and second provisional measures requested by Sudan aim to preserve these two rights. They fully satisfy the requirement that there must be a connection between the rights claimed and the measures requested. The first measure concerns the obligation of the United Arab Emirates to prevent genocide. As the court has stated, the obligation to prevent genocide is a due diligence obligation that requires states parties to the convention to take, and I quote, all means reasonably available to them to prevent, as far as possible, genocide. End of quote. The second measure concerns the obligation not to commit acts of complicity in genocide, which, as you have stated, and I quote again, undoubtedly encompasses the provision of means intended to enable or facilitate the commission of the crime. End of quote. The two measures requested have a general scope. They aim to cover all the actions of the United Arab Emirates that contribute to creating a risk of irreparable harm to the plausible rights claimed by Sudan. They aim to ensure that the United Arab Emirates cease any behavior that could constitute a form of aid or assistance to the rebel forces in the commission of genocide, and also to ensure that all means available are used in order to prevent that new acts of genocide be committed by these forces. This specifically implies ending delivery of weapons, ammunition, and other forms of military or logistical assistance to the rapid support forces and other militias responsible for the acts of genocide against the Masalit community. It also involves ending any form of financing that could be used to help or assist the rapid support forces and other militias in the commission of genocide. It also involves, last but not least, taking all the necessary measures to ensure that individuals, companies, or organizations under its jurisdiction or influence provide no aid or assistance to the rapid support forces and other militias participating in the commission of genocide. The third measure requested by Sudan is of a procedural nature, and it aims to require the Emirates to submit a report to the court on all the measures they will have taken in execution of the court's decision. In our case, such a measure is all the more justified inasmuch as the Emirates have always denied having helped or assisted the rapid support forces, particularly through the provision of weapons. Therefore, considering the monitoring of the implementation of these measures indicated by the court, this request seems necessary. Mr. President, a genocide is being committed in Sudan. This genocide is being fueled by a state, the United Arab Emirates, which, in violation of its international obligations, including those that emanate from the Security Council, has continued to provide weapons and other forms of aid to the militias directly responsible for this genocide. The United Nations Security Council, the Peace and Security Council of the African Union, and several states have condemned the external interventions fueling the Sudanese conflict and have called upon the states facilitating the transfer of weapons and military equipment to Darfur to respect their international obligations. This request from the international community has remained unheeded up to date. Now, given this situation, the court's role as the ultimate guardian of the Genocide Convention's adherence becomes of paramount importance. Sudan is requesting that the court fully comply with the role entrusted to it by the Convention. To conclude, I would like now to thank you for your attention and request that you kindly give the floor to the agent for Sudan.
I thank Professor Palchetti for his statement. I now give the floor back to the agent of Sudan, His Excellency Dr. Muaiwa Osman Mohammed Khair. You have the floor, sir.
Mr. President, member of the court, that concludes the oral argument of the Republic of Sudan. All that remain is for me for be Sudan's submissions as set out in its letter to the court dated 3 April 2025. The Republic of Sudan requested that pending final judgment in the case, court indicated that the United Arab Emirates shall, in accordance with its obligation under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Masalid group in the Republic of Sudan, take all measures within power to prevent the commission of all acts within the scope of Article 2 of this Convention, in particular, a killing member of the group, 2 causing serious body of mental harm to the member of the group, deliberated inflicting on the group condition of the life calculated bring about the physical discretion in all or part, and imposing measures intended to prevent base within the group. The United Arab Emirates shall, in accordance with its obligation under the Genocide Convention relating to the member of the Masalid group, refrain from any conduct amounting to complicity in a commission of any of act described in point 1 above by any irregular armed unit or by any organization or persons. The United Arab Emirates shall submit a report to the court on all measures taken to give effect to this order within 1 month, as from that date of this order, and thereafter every 6 months until the final decision on the case rendered by the court. Mr. President, members of the court, my country, Masalid people, thank you for kind attention at this desperate time. I also thank you, the interpreter and the court staff, for unavailable assistance. Thank you.
I thank the agent of Sudan, whose statement brings to an end the single round of oral argument of his government, as well as this morning's sitting. The court will meet again this afternoon at 4 p.m. to hear the United Arab Emirates present its single round of oral argument. The sitting is adjourned.